and it's a legal perspective. I will look at it from a legal perspective, purely legal perspective. So this amendment, which was brought by Finance Act 2021, has some significant changes, which has tried to circumvent some of the judgments of the high courts and as well as the Supreme Court. And I will show how it has done that. And it has also imbibed some of the laws laid down by the Supreme Court into while bringing these amendments. So let me start from the very first section, section 147, which deals with reassessment of the escaped income. So the first thing you notice when you go through the section 147 is that the words reason to believe, which is very significant words, these words have been omitted. So therefore there is no specific, you can say there is no specific statutory guidance to assessing authority when he exercises his power under section 147. Such omission creates opportunities for arbitrary exercise of power by AO. Why I say so? Because procedural safeguard is must because assessment or reassessment in particular, these have civil consequences. Civil consequences is a terminology which has been recognized by the Supreme Court in 1980 judgments, in which court says that any exercise of power which will have financial or even otherwise civil consequences for the for any person must be tested on the anvil of whether that procedure established by law is reasonable or not. And why reasonable or not? Any procedure which has been established to undertake or to exercise that power by an authority has to be tested on the anvil of just, fair, and reasonable, which was a law in respect of procedure laid down by the Supreme Court in 1978 in Menka Gandhi case. So that is the constitutional ground on which any kind of procedure, whether it be in criminal or even the tax or any other law, on which it is tested. So this omission of reason to believe will have it has, since it is a new legislation, and but it, in my opinion, it will be tested by the High Court as well as it may be tested by the Honorable Supreme Court as well. And that why it was omitted, and if its validity challenge of validity of section 147 is challenged, then for being unreasonable and if it is being unreasonable, if the procedure is unreasonable, or divide of the reason being divide of being procedure being having the component of reasonableness, then it can be held unconstitutional. To save it from that being unconstitutional, courts might read that even though these words have been omitted, reason to believe have been omitted, even then it could be the exercise of power by the AO while exercising his power under 147 must be a reasoned one, must be one which must inform the reason, and which that is because several judgments over a long period of time have said that any information based on which assessing officer reopens a case which assessment has already been made, then that assessing officer must form his opinion on the basis of information which must have a live link with the formation of opinion. So courts have always held an opinion that the reasonableness must inform the power of the assessing officer while reopening the case. So just by omitting these words, AO cannot have, even though there is no statutory guidance for him, the AO cannot, in my opinion, AO cannot become unreasonable. He will still have to give reasons which those regions must have a live link with the information on the basis of which he is opening the reassessment procedure. So that is the one thing that I wanted to bring out now. But however, on the one hand, reason to believe has been removed. On the other hand, under section 148, some a new criteria has been added, and that the reassessment can be a reassessment procedure can be undertaken by the AO on the basis of information. Earlier, this was missing under section 148. but now it has been added, and mainly, but what could be this information? This information could be any information in case of SSC for relevant assessment year in accordance with risk management strategy formulated by the board from time to time. Any audit objection to the effect that assessment in the case of SSC for relevant assessment year has not been made in accordance with the provisions of this Act. Any information received under an agreement referred to in section 90 or 90A, that is double taxation avoidance agreements, and any information made available to the AO under the scheme notified under section 135, that's the faceless scheme. Any information which requires action in consequence of order of a tribunal or a court. So here the information is coming from various sources to the assessing officer. But as I said, this amendment, this Finance Act 2021 amendment has created, has removed the reason to believe and has brought into the picture only some information which has been categorized under section 148, but nowhere it says that whether on the basis of this information, the AO must apply his mind. So it doesn't say anything on that. It doesn't say whether it's almost automatic, as if this information is there, whether AO should exercise his power, exercise his mind or not, must apply his mind or not, and straight away he should undertake the process of reassessment. So I think that this amendment act in this way has some serious issues which may be dealt with by the courts in due time. Now, see what are the consequences, how to look at just as discussed in the previous slide. So omission of reason to believe rendered the judgments which laid down legal principles of live link between information and formation of reopen and reassess change of opinion, which was also very significant, that on the basis of same information, you cannot, particularly in those cases where there has been scrutiny assessment, you cannot reopen the case. So what will happen through those cases? Because now reason to believe has been removed. But again, as I'm saying, that in my opinion, courts will hold the AO to the same principles which has been laid down by the courts earlier. Otherwise, because of constitutional principles of procedure being just, reasonable and fair, this amendment may not survive. To make it survive, a reasonableness component will have to be read into section 147, even though reason to believe has been removed, has been omitted. And some of the judgments I have quoted that in which these legal principles were laid down. And I have already discussed the constitutional law principles of Maneka Gandhi, based on which this reasonableness must be read. And one other aspect, if you look at it from constitutional angle, is that these powers, when you have given the unguided discretion to assessing officer under section 147, then that will create an arbitrary exercise of power. There are chances of being the power arbitrary will be very high and very frequent. So that discretion cannot remain unguided. So therefore, the only option available would be if a statute does not bring any further amendment into it and which provides guidance for exercise of power, the courts will definitely read that either it will be held unconstitutional, or court will read that, see, you cannot exercise your power in an arbitrary manner. There must be some guidance, and looking at that, the previous judgments of the courts will be followed even after these amendments, which deal with the arbitrariness or unreasonableness. So all those cases will be dealt with just to save it from being unconstitutional. Now, one very good thing this amendment has done is that under section 148A, they have brought a very good procedural safeguard as far as 148A is concerned. And they have followed, in fact, they have followed very well judgment laid down by the Supreme Court, the procedural safeguards laid down by the Supreme Court in GKN Drive Safts Limited versus ITO 259 ITR 19 Supreme Court. So those guidelines have been codified in section 148A. That is really good thing that they have done. So these guidelines are, and these procedural safeguards are that as AO with prior approval of the specified authority needs to conduct inquiry under section 148A, small a, if required with respect to information that suggests the income chargeable to tax or escape assessment. Therefore, he has to conduct first an inquiry with prior approval of the specified authority. Then again, with prior approval of the specified authority, he will provide an opportunity to the SSC, and SSC may reply within 7 days or at maximum within 70 days, which may be extended on the application by the SSC to the AO. And then after considering his reply of the SSC as well as other materials available with the AO, which must be given to the SSC when he gives the notice of 148 capital A small b, then he will have to, after considering the reply of the SSC and those materials, he can pass an order under section 148 after prior approval of the specified authority. So this procedure, these safeguards are not available in the case of urgent requisition cases. So that can be dealt with later. It's these safeguards are really very good, and it has 148A capital A has codified the procedural safeguard which were laid down by the Supreme Court in GKN types apps. Now, reassessment proceeding in search and survey and requisition. So section 148 explanation 2, in search and requisition and survey cases, AO shall be deemed to have information based on which he can initiate the assessment proceeding. So deeming, it's a deemed that he has information. There is no requirement of him providing information. It will be deemed. I think it will also create some problems. Then procedural safeguard of section 148 is not available to the SSC in whose case reassessment proceedings have been started pursuant to. See, procedural safeguard of 148 are embodiment of principles of natural justice. So even in search, survey, and requisition cases, SSC cannot be deprived of the principles of natural justice. So this will also give birth to several sorts of litigation. And hopefully courts will protect on the basis of principles of natural justice, and these procedural safeguards must be available in those cases as well. Now I will come to the time limit for issuing notice under 148 and which are provided one. So this has also undergone a significant change. Earlier it was 4 years or more than 4 years. Now it's 3 years from the relevant assessment year, and in certain exceptional cases it could be up to 10 years. So 10 years are in cases in which the amount could be 50 lakh or more. And later on, 1A was added in section 149, in which even if this 50 lakh is not in just one assessment year, but it has been spread out in more than one assessment year, then also this extended period of time limit will be there. So yes. And now I will come to section 151. There is also saying, if you go to the previous section 151, that uses the word satisfaction as far as the specified authority when they exercise their mind. Now that word has been removed. The satisfaction of the specified authority, which are higher authorities or above the assessing officer, those that word has been taken away, and instead it just says the prior approval. At least is prior approval of the specified authority, as if it is some kind of mechanical thing. So it can't be the procedural aspect of it. The prior approval cannot be only a mechanical thing or just an exercise, just an additional exercise. A kind of just it has to be done in a routine manner. Or no, it can't be. It must be, even though they have removed the word satisfaction, but a specified authority will have to apply its independent mind over the material provided by the assessing officer while granting or not granting the approval. Otherwise, the very requirement of granting approval as prior approval will have no meaning if there is no application of mind. So even though statute, this amendment is silent, and it has been the word satisfaction has been removed, which was earlier there under section 151. In my opinion, because of the constitutional law principles, it will be read by the courts that 151 requirement is not merely an empty exercise, and the specified authority will have to exercise its mind and apply its mind, and after that, only after that it can grant approval or may not grant approval. So there are in 151 different specified authorities have been mentioned in case of 3 years, or if the case is ever 3 years. So these are the legal aspects, and this is small talk I wanted to cover, that how except for imbibing the procedural safeguard in section 148A, there is much things. I think it will evolve through judicial interpretation of section 147 in view of the fact that reason to believe has been removed, and also section 151 in which the prior approval has been, and the word satisfaction has been removed, and because prior approval cannot be merely an empty formality, as well as in search and seizure cases as well. In my opinion, same safeguards must be provided. Otherwise, because those safeguards are like principles of natural justice, which are well recognized, and they must be provided so that so that it could be that it is not it doesn't become arbitrary or unreasonable. Okay, so thank you for this. I think my time is over. And thank you.